rise. The Court of Appeals is now in session. Please be seated.
Good morning and welcome to the Court of Appeals today. Hold on, sorry, I just combobulated. Only Judge Orm gets the microphone up here.
Oh, well, seniority has its dividends.
My name is Michelle Christensen Forrester, and I am the presiding judge of the Utah Court of Appeals. I'm here today joined by my colleagues, Judge Gregory Orm and Judge David Mortensen, and we will be hearing argument in two cases today. Let me first begin by thanking we're in this brand new courthouse and it's beautiful. And let me begin by thanking Chris Morgan, who is the trial court executive here in Manti, Linda Ecker, who is the clerk of court, and Raydon Payne, who is our support services coordinator. So thank you all. You're here. Thank you very much for inviting us and allowing us to hear arguments today.
And Steve Latham for coming down.
Oh, and Trooper Steve for coming down to protect us as well. Our first case that we're going to hear is the State of Utah versus Abonza. If I could please have counsel enter their appearances for the record.
Your Honor, Tristan Thomas, counsel for the state.
Wendy Brown for the appellate. Thanks for making the drive down. Appreciate it. Just for to explain a little bit, counsel's familiar with how our clock works and how everything goes, but to explain a little bit, in an appeal like this, each side has 15 minutes in which to make its arguments. Appellant, because it's their burden to prove their case on appeal, can decide to split their time, argue first, and then reserve a little bit of time to rebut what is argued by the appellee. It looks like, Mr. Thomas, you have reserved 2 minutes for rebuttal?
Yes, Your Honor.
Okay. And I think that's probably, do you have any questions before we begin our argument?
I don't think so, Your Honor.
Okay, great. I will remind you to make sure to stay at the podium and speak into the microphone. I have my microphone here, but we're live streaming, and for those that go back and listen, we need to have, so make sure that you enter your appearances every time you take the podium as well, so that the record is clear as to who is speaking. And if you're ready, you may begin anytime.
Okay, thank you, Your Honor.
Excuse me.
Okay. All righty. So, Your Honors, my name is Tristan Thomas. I'm representing the state of Utah as the appellant in this case. This is the first time I've ever appeared before this court. That being the case, would the court like my bar number? I don't know if that's okay.
We're all good.
Okay,
See it on here.
Okay, thank you, Your Honor. Okay, so before I guess getting into the argument I'd like to make before this court today, would the court like a brief recital of the facts?
No, we've read your briefs.
Okay.
I do have one question that I didn't see.
Oh, sure.
I think, could you maybe describe the roadway a little bit more about where the stop took place?
Certainly, Your Honor. So the stop.
How close was it to town, that kind of thing?
From my understanding, Carbon County is ultimately it's pretty rural. So town would have been potentially, or at least houses may have been potentially a quarter of a mile away. It was rural, but I wouldn't necessarily say out in the complete middle of nowhere. I don't know if that helps. The road would have been, it's a commonly, it's a busy road with vehicles that go between 50 to 60 miles per hour on it. So it's not a slow road, but I wouldn't say it's like out in the boonies. Nope. Okay. So, Your Honors, getting into the particular facts, well, not facts, obviously, but just the material that was suppressed by Judge Torgerson, that the state is looking to have, will have that overruled. And ultimately, what the state is asking for is to have this issue remanded to the district court so Judge Don Torgerson can make, of the 7th District, can make an ultimate decision as to whether or not the inevitable discovery doctrine applies. It was briefed to the court. It was also offered in argument during the suppression hearing, but Honorable Judge Torgerson just didn't rule on that particular matter.
So what exactly was the evidence that was going to inevitably be discovered?
Yes, Your Honor. So the evidence that, according to the state anyway, was basically inevitable. It was going to happen regardless of police misconduct. Is one, well, your observations of Mr. Abonza, the appellee, the evidences of impairment, watery, glassy eyes, slurred speech, difficulty forming complete sentences, the odor of an alcoholic beverage emitting from his body, all of that evidence while he was within the vehicle, but also all that evidence of those signs of impairment after.
Is any of that a crime?
When he was inside the vehicle, Judge Torgerson determined that as long as he was inside the vehicle, there was no crime.
Do you agree with that? You phrase it as Judge Torgerson thought. That's not my question. My question is, objectively, is that a crime?
Your Honor, I would say, I think I'm leaning towards no, personally.
Let me ask this then. If Mr. Abonza had said to the officer, I would like to take 2 steps to the curb and call whoever to come pick me up, would there be a crime?
In that case, Your Honor, I guess that gets a little more close to the line. I would say if Mr. Abonza was taking steps to get someone to come pick him up, I don't think we would have had a crime.
What I'm trying to figure out is what you're saying, that evidence is going to be inevitably discovered, and I just can't get my head around evidence of what. Because I think what you want to get to is if he had been allowed to proceed and walk down the street in a manner that posed a danger to himself or others, like if they thought, man, this guy's so drunk, he's going to walk out in the middle of traffic or something, then we have an issue. But I'm just having trouble wrapping my head around that kernel of what exactly is going to be inevitably discovered. It seems to be
Speculative. I share the concern.
and conceptually difficult to understand, since what you're saying is usually with an inevitable discovery case, the crime has already committed. The classic case is there's a violation of rights in the way that the officers found some drugs, but we can point to some circumstances that leads us to believe that they would have been found anyway, and so then we're like, oh, that's inevitable discovery. But the crime, possession of drugs, was committed before the officers arrived, already happened. Here in this case, I think, unless you can correct me, we haven't pointed to a crime that had already been committed. So that's why I'm stuck on this. What was inevitably evidence of what crime was going to be inevitably discovered? I think what you're telling me is not only were we going to discover evidence, but we're also going to have a crime committed future tense. Is that wrong way to talk about that?
I wouldn't say so, Your Honor. I think ultimately Judge Torgerson determined that officers arrested Mr. Abonza too early, before probable cause for intoxication had become apparent. However, considering the fact that Mr. Abonza was required to leave the vehicle and he refused to make any phone calls, accept a ride somewhere, basically what was going to happen is he was going to leave.
He had made a
the-
call. Wasn't he talking to a woman at one point while he was still in the car?
Yes, yes. Well, he was, but in that conversation he had with this individual on the phone, it wasn't a request to, hey, come get me finally. It was rather a desire to complain that the police were arresting him. So really, at the time when he exited the vehicle, I mean, the first thing the officers saw right before they arrested him was him stumbling. And of course, all those other signs of impairment were there as well. And considering the defendant was not making any attempts to remove himself safely from the situation, what was inevitably going to happen is he was going to step out of that vehicle and start to wander off or even just sit there intoxicated by the side of the road.
Well, okay. And far be it for me to tell law enforcement how to do their job, but by jumping the gun a little bit, we end up with this speculation. If he would have said, I'm just going to walk on home, and the officer said, okay, best of luck to you. And he heads out and he's weaving and wandering. He's in the lane of traffic. Public intoxication, bust the guy. But if he gets out and makes an effort to get clear over, along, I'm picturing this rural area, he is off the highway. He is on the easement, really closer to the fence line than the highway, and yeah, staggering a little bit, but heading in a straight line off the highway towards home or a friend's house or wherever. We still may not at that point have a crime. We need for his behavior to move to a point where he's a danger to himself or others. I mean, he may also say, you know what? I'm going to call my wife to come get me in a minute, but she's going to be ticked off. So I'm just going to sit over here by the fence on the side of the road, but I'll take care of this. That's probably not public intoxication either. So it's entirely possible, well within the realm of possibility, that he was going to be guilty of public intoxication. But I can see scenarios, as did Judge Torgerson, in which, no, he, despite our expectation, he just went and parked his butt over alongside the fence, or he walked way off the road in a safe manner. We end up with no crime.
Yes, Your Honor, and I do feel that Judge Torgerson, that was his mindset as well. And I guess one thing that I think is key to this case is the purpose of the exclusionary rule, as put down in Nix versus Williams. The purpose of the exclusionary rule is to deter unlawful police conduct. And it's not to give a windfall to the defendant for a mistake on the part of law enforcement. And I think this case highlights that. Did law enforcement ultimately jump the gun a little too early? I think, yeah, probably. However, should the defendant get the benefit of that slight error? A good example I would actually say is this is a juvenile case I wanted to mention. It's a State ex rel MV versus State. It's a 1999 Utah Appellate Court case. And in that case, a juvenile was detained by an officer while walking in a high crime area during school hours. So his reason for taking the juvenile into custody was not for the commission of a crime, but just because they were delinquent outside of school. The officer didn't have a reason to suspect the juvenile possessed a knife, but he conducted a frisk of the juvenile and uncovered a knife in the juvenile's pocket, which was unlawful for him to have. So ultimately, this issue came up. There was a suppression hearing, and ultimately it came before the appellate court. And the question was, well, the officer didn't have a reason to frisk that student, that juvenile, on the street for weapons. So he, like in our case, jumped the gun a little bit. But what was determined in this case is that since upon arrival at the juvenile detention center, the juvenile was going to be examined and was going to be searched anyway, the court found that the exclusionary rule should not apply since the evidence of that knife was ultimately inevitable in its discovery. And I would say we have a very similar situation here. I don't believe that.
Was it inevitable because he was going to take him into custody for truancy?
Yes, Your Honor. It was inevitable because at that point he had a reason to arrest, or, well, take him into custody and then take him to the detention center.
It was the truancy.
Yes, yes.
How's that? What's the truancy in our case? What's the crime? I'm kind of circling back to my.
Yeah, no, I understand. Ultimately, Your Honor, it is different in that when officers arrested Mr. Abonza, there may not have been a crime yet. I guess what I'm trying to highlight is the fact that in both cases, law enforcement jumped the gun, but that didn't necessarily merit suppression of the evidence. Ultimately, I think if we were to apply the exclusionary rule in this case and suppress the evidence of Mr. Abonza's intoxication, especially his behavior when he was arrested, which indicate with resisting arrest and all the signs of impairment, I think suppressing all of that really only gives the defendant a windfall and doesn't really help catch law enforcement and tell law enforcement, hey, you need to do something better. Really, law enforcement, I guess, they jump the gun. But I don't think that necessarily means the exclusionary rule should apply.
Can I ask you, you're out of time, but because we're asking
Oh,
you
yes.
your full rebuttal time, to address the Mr. Abonza's argument in the red brief that you didn't address prejudice. Is that just because prejudice is sort of a given here? The prejudice to the state is sort of a given, right?
That was my understanding. I understand that typically, you need to show prejudice in order for something to be worthy or appropriate for appeal. My reason for not including that is just, to me, it was apparent. The evidence was suppressed, and Judge Torgerson then dismissed the entire case based off of that order of suppression. So I just took the issue of prejudice as a given in this matter.
Thank you, Crystal.
Okay.
Mr. Thomas, point of personal privilege, congratulations on an excellent first argument before the Utah Court of Appeals.
Oh, thank you. I appreciate it.
See you on rebuttal.
I may have said the same thing to Ms. Brown many years ago. I won't be saying it today.
That's fine. May it please the court, Wendy Brown on behalf of the appellee Hector Abonza. The district court was proper in granting the motion to suppress, and in arguing otherwise, the state misapplies the inevitable discovery doctrine. It confuses the idea of evidence yet to be discovered with a crime yet to be committed, and for all of the reasons in our briefing, this court should affirm. There are a couple of points of clarification I'd like to go into. Oh,
Can I just ask, up front, maybe inevitable discovery is not, conceptually, it's not exactly on point, but the second Mr. Abonza got out of the car and started, as, Judge Orm was talking about, started walking down the road, isn't that, at that point, he could have been arrested for public intoxication. So, help me conceptualize this.
and I would say maybe he would have been arrested, depending on if the way he walked made it clear that he was a danger to himself or others. And I think the fact that in questioning the appellant, this court asked several times if he had done this, that really highlights, as Judge Orm said, the speculative nature of the state's argument. And in Nix versus Williams and all of this state's cases applying it, it requires the state to show that evidence would have been discovered, not just that it could have been discovered. And I guess more to that point, again, this really is a distinction between a crime not yet committed versus evidence not yet found. And I think that the state's argument that this was maybe a small police error, I think it used the term slight error in its argument, is completely misstating what happened here. Mr. Abonza was arrested, the most severe form of a Fourth Amendment seizure that can take place, arrested without probable cause, without a warrant, without an applicable warrant exception. This is not a slight error, and this is precisely the type of case where the exclusionary rule will deter future police misconduct, because the next time these officers go to arrest someone, they'll make sure that a crime has been committed. I also think, as to the factual clarifications that I wanted to make, the state in its briefing and again in oral argument talked about the fact that Mr. Abonza had been offered a ride home. In page 122 of the record, the court suppresses that statement as hearsay and says, I won't consider that for purposes of the suppression hearing. So before this court, there is no evidence that Mr. Abonza was offered a ride home. And I think even more than that, the body cam video shows that Mr. Abonza was doing everything he could to assert any constitutional rights that he might have had in that setting. He was intoxicated, and we don't dispute that. And so he might not have been directly on point with what those rights were, in that he wanted a lawyer. But the district court made a finding that he wasn't obligated to identify himself at that point. He wasn't obligated to say where he was going. Again, this is a case not of a slight error by police, but instead of someone who had not yet committed a crime, was attempting to assert their constitutional rights, and again, had the most egregious Fourth Amendment violation that could have existed put against him.
Can I ask you, I was trying to think of corollaries here, and the one I thought of was drunk driving, the prototypical case that we see. Somebody sees somebody leaving a bar, and they think their suspicions are raised, and often accurately, that this person's driving a vehicle under the influence of alcohol. They call the police, and an officer shows up, and almost always they have information that substantiates a pretty good hunch that this person's driving DUI, but they don't pull them over at that instant. They follow them for a minute, and they wait for something. Failure to signal, rolling through a stop, driving over a line. Usually, even when they do it once, that's not enough. We're going to wait 2 or 3 times, and then like, okay, finally, that's enough. I'm pulling you over. Now I've got some probable cause. It seems like what we're saying in this case is similarly, if you want to kind of look at this as a corrective measure with the exclusionary rule, that what we should have been asking for them is to let him take at least a couple, 3 steps to see if he truly is a danger to himself and others. Is that what your position is? Is that a fair corollary?
I think so, with the caveat that with the example of the drunk driving, the minute that person got behind the wheel, they've committed the crime of drunk driving, of DUI, right? They're in physical, whatever it is, control of the vehicle, actual physical control. And so, yes, we see a lot of times where officers will wait to observe additional information for reasonable suspicion for that stop. And so in order to do that here, there had to have been something else that happened that the officer observed to indicate that Mr. Abonza was going to be a danger to himself or to the community at large.
Let me follow up on that.
Yes.
And it is kind of connected with Judge Forrester's question. If, I guess my question is, could a person be drunk enough sitting in a car and knowing that they have to leave the car if the car is going to be impounded or something? It would seem that a person could be theoretically drunk enough that allowing them to even take those steps would be a danger to themselves. Like, this person's so wasted, they are going to fall over and, hurt themselves. That would seem to be a crime the minute they try to move then, no?
Depending on how strong the evidence was, I do think maybe conceivably we could have a case where the danger to the person's self was so apparent. I don't know if walking gets you there, but let's say he has an open alcohol container and he's trying to light a cigarette, and there's just something else here that makes him very dangerous to himself. he could have committed that crime, sure, sitting in the vehicle. But what we have here is a factual finding from the district court that as Mr. Abonza sat in the car, he was not yet a danger to himself or others. And when you watch the body cam video, he's in the car when the officers say, "I'm detaining you for public intoxication." So when the court makes this finding that they arrested him too soon, it's making this finding that there was no crime yet committed. He was sitting in the vehicle, not a danger to himself. He was not in violation of the public intoxication statute.
That potential was there,
Absolutely.
the possibility, but it hadn't yet ripened.
That's exactly correct. And so there was also that possibility that he gets out of the car, says, "Oh, I'm not steady on my feet. I need a ride." Gets an Uber, calls someone to pick him up, says, "Can I sit here in the grass until someone can pick me up?" I mean, the whole universe of possible things that could have happened is so wide that that shows why the state has not met its burden under the inevitable discovery.
And your point is, at this point on this record, regardless of what the reality was, maybe he was that drunk, but since the court made the finding and the finding's not been appealed, that's where we are.
Yes, and it's not even, the Due South case makes it clear that we're not even necessarily looking at the degree of intoxication. It's what other actions is this person taking to create a danger to themselves or others. And so both of those are missing in this case. I also want to briefly talk about state XRL MV, which the state brought up. The reasonable suspicion to stop the juveniles was truancy, but as soon as he got the juveniles MV's identification and looked it up, there was a juvenile court pickup order on this kid, which is the equivalent of a warrant for arrest. And so there was a very legitimate, judicially overlooked reason to take him into custody. And then the court made the determination that that knife would have been discovered as part of the search of his person at the juvenile detention facility. So I actually think MV is a great case for you to look at for a foil for what is so different in this case. Not only, I mean, MV had committed the crime of possessing cigarettes as a juvenile. He was potentially truant, and he was in possession of a dangerous weapon as a restricted person. There were crimes already committed. It was just that the knife would have been found later on down the line. Here, we don't have a crime that's been committed. We don't have the equivalent of a warrant for picking up Mr. Abonza, and we don't have that information yet to be discovered.
It's like, say, suspicion of a DUI, somebody gets arrested, car gets impounded. Well, it turns out, no, there
Yes.
was no reasonable suspicion or probable cause to arrest, but they find drugs in the car.
Exactly. And I actually
And
think
that's not this case.
And
Right.
we say that's inevitable because law enforcement is duty-bound to conduct an inventory search. So we know the drugs are going to be found in the course of a proper inventory.
that's exactly correct. So even taking the facts of this case to switch it to a hypothetical that might fit that, there were knives found in this car. The driver claimed possession of them, and the weapons charge was kicked at the prelim against Mr. Abonza. But let's imagine a hypothetical universe where that didn't happen. The knives are in his reachable area. He goes and gets a ride and is, safely taken away. But upon that inventory search, they find those knives. Okay, he now can be charged with that. That same hypothetical could then apply to see if the independent source doctrine might apply. But we just, the facts are so different in our actual record.
And there's a crime.
And there's a crime. I also just want to point out the correct remedy in the case that this court sees the need to reverse. I don't think that the state in its briefing asked for a remand as to the determination of the applicability of inevitable discovery. I think that this court can make that determination on its own. It has the record developed. It can make the determination of whether the district court properly granted the motion to suppress, which it did. And also on the point of briefing prejudice, I'm not here arguing that the state wouldn't have been able to make a showing of prejudice. But if I were briefing on the other side and I didn't include a prejudice argument, there's no way I would get a reversal. And so I would just say that that is the appellant's duty. It was not met in a very technical sense here.
And I think that's true, but I think the point is well made that prejudice here needn't be belabored. The state lost the ability to use any of its evidence. And if we say Judge Torgerson got that wrong, the evidence should come in, it doesn't take a lot of heavy lifting to figure out that prejudice follows rather automatically. If they were deprived of their critical evidence and convince us of that fact, the prejudice seems pretty obvious to me.
It does, and it's not a heavy burden, but it is a burden. And I just think on the technical requirements of Rule 24, the state didn't meet that here. But of course, there are plenty of other reasons why this court should affirm. And if there are no other questions, we'd ask that you affirm the district court. Thank you.
Thank you. Mr. Thomas, it's time for your second appearance. Or the Utah Court of Appeals.
All righty. Well, thank you, Your Honors. I guess I only have 2 minutes, so I don't need to say I'm going to take very long. But I think something important to remember when considering the applicability of the inevitable discovery doctrine, but also the purpose of the exclusionary rule, is ultimately, the idea of the exclusionary rule is to deter unlawful police conduct. And I think to some degree, even regardless of the outcome when it comes to inevitable discovery, I think it should also be considered whether or not the exclusionary rule should actually apply and suppress evidence. I mean, when you think about it, officers have a duty to protect the community. Should officers be required to do nothing until something's already happened and then they do something? So in this
But
case,
that's a different doctrine. You're maybe arguing for a new doctrine or a different kind of application of the caretaker function that didn't get briefed. You may be onto something there. The officers were saving this guy from himself. He was clearly drunk. Nothing good was going to come of letting him out. And so, yeah, they jumped the gun, but it was to save him from himself, to save the public. So you've got a different doctrine than maybe inevitable discovery. But it doesn't seem to me that you can shoehorn that concern into the inevitable discovery doctrine as we've understood it heretofore.
well, and no, Your Honor, I'm not trying to say that's the new argument the state is trying to make. Ultimately, the inevitable discovery doctrine, that all this was going to inevitably occur, that's ultimately what the state is trying to say. And I think the mistake of the district court was being a little too, I guess, comfortable with excluding evidence. I mean, the exclusionary rule or the inevitable discovery doctrine, I think that would apply here. But I also think that, when you're considering the suppression of evidence, you also have to consider the purpose of the exclusionary rule and whether or not that is served by suppression. So even, let's say, if the court is unconvinced about inevitable discovery, I would still think that with the exclusionary rule's purpose, it would not be satisfied here, and instead it just grants a windfall to the defendant. Okay, thank you, Your Honors.
Thank you. Thank you, counsel, for your arguments today. We very much appreciate them. Thank you for your attendance here. And we do have another argument, but that won't begin for 25 minutes. So we'll be in recess until 11 o'clock.
All right.